and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Colin the Caterpillar cakes and commercial lease strategy. That's two phrases you never thought you'd hear in the same sentence, but that's exactly where we're heading today. We're looking at a recent decision, Park Cakes Limited and Caterpillar Property Limited. If you're a tenant with an option to renew, the key question is, do you follow the contractual route set out in your lease, or do you rely on your statutory rights? As we'll explore, the answer isn't always obvious, and getting it wrong can have real consequences. Richard's going to walk us through this, including how market rent is assessed and where upwards and downwards rent reviews come into the mix. So, whether you're advising on leases, managing assets, or just want to understand how these clauses work, settle in, get a cup of tea, and of course, your choice of Caterpillar cake. Hi, Richard.
Hi, Lizzie. What have you been up to lately?
Not a lot, not much. It's a Friday afternoon, so we're on the home straight to the weekend, and we've got another case to talk about. This one has piqued my interest because it's called Park Cakes and Caterpillar Property Limited. So all I can think of is Colin the Caterpillar.
Well, you're not wrong, Lizzie, but not for the right reason. But Park Cakes, I looked at this. I looked into it, quite separate from the law report, so I hope I'm right. Park Cakes produce cakes for Marks and Spencers and have done for 80 years, including Colin the Caterpillar cake.
Fantastic. Well, I think we're getting off to a good start if the cake.
Yeah, and they sell over 1 million Colin the Caterpillar cakes every year.
Crikey.
So there you are. So you're
not sure how many of those they've sold to me, but a fair few.
Yeah. And they're based in Oldham. They've got a couple of leaseholds of a couple of manufacturing sites in Oldham and Greater Manchester, which were the subject matter of the case.
So the case was at Leeds Business and Property Court, and the decision was on the 20th of March. And it's all about options in leases and whether any subsequent leases will be in the 54 Landlord and Tenant Act. So do you want to tell us what the problem was with this case, the background facts?
Well, it's Section 28 of the 54 Landlord and Tenant Act, which basically says, I'll paraphrase it, it's where the landlord and tenant agree to grant a future tenancy on terms and from a date specified, then it won't come within the 54 Act. And it's obviously intended to deal with things like agreements for lease between the two parties. If you then subsequently grant a lease, it's within the 54 Act, but not the agreement for lease. But it's a tricky issue. Options generally are a tricky issue, as we'll perhaps see. The question is basically, is an option to renew a lease a grant of an agreement to grant a future lease? Because if it is the future lease, you can exercise the option, but if you do, the future lease won't be in the 54 Act if it's exercised via an option to renew, which would be a bit of a major gap in the legislation if that was the case. I have seen arguments about it years and years ago, actually. But this is what the case was about. Both landlord and tenant wanted a new lease. They had an option that could be, if it was exercised, it could be exercised at the end of 17 years by 12 months notice. And the end of 17 years was June the 13th, 2023. What the landlord wanted to basically argue is that it was on the same terms apart from the rent. And there was a fixed method of calculating the rent. If you come within the 54 Landlord and Tenant Act, Section 34, in the absence of agreement between the parties, basically says you're entitled to a market rent. And the landlord wanted to use this fixed formula because they could get more rent than a market rent. People miss the point a little bit because Section 34 is basically the potential upward and downward rent review if you're within the 54 Landlord and Tenant Act. If the rents are falling, then you get a lower rent. But I'll leave the detail of that to the valuers of this world. So that was the basic argument, is an option, an agreement to grant a future lease, in which case the future lease will not be within the 54 Act.
Okay, so what did they say? What did the court say?
Well, there's a lot of arguments, quite cogent arguments, which I must admit I haven't thought about too much. There was one case I'd I'd come across this case years and years back. A case from 1991, a High Court case called Spiro and Glen Crown, which is about options to purchase freehold on property in Finchley. But because the problem is in 1989, the Law of Property Miscellaneous Provisions came in to replace the predecessor, Section 40 of the Law of Property Act, and Section 2 of the Law of Property Miscellaneous Provisions that basically says that contracts in land, with a few exceptions, must be in writing, contain all the express terms in one document and be signed by the parties. And so what's the consequence of that? Not an option to renew, but an option to purchase. Because the option to purchase was in writing, contained the express terms signed by the parties. But then when you exercise the option, is that a separate sort of provision, contractual provision? Because, the person subject to the option, if it was, could just render the option to purchase null and void, worthless, because they just don't agree to sign anything. And Spiro and Glen Crown, which is a bit of a policy decision, it was a lacuna as in the original legislation, basically said it's just the actual grant of the option and not the exercise that has to comply with Section 2. But the argument went that if that's the case, then, does that have any bearing on this? Could you actually say that the grant of the option to renew the lease is the sort of legally binding part, if you like? And the court, to some extent, I can understand why, but glossed over that. Because if it is the legally binding part of it, then the argument holds. But other cases, it said that referred to the fact that basically, well, if they said that an option is up to the tenant, it's not bilateral, it's unilateral. The tenant agrees the option, then at a later stage, the tenant doesn't have to be bound to exercise the option. The landlord, subject to provisos and conditions precedent, might have to be bound to actually sort of grant the new lease, but it's one-sided, and that tenant isn't, and it's not the same as sort of Section 2 of the Law of Property Miscellaneous Provisions Act. And they also said that you're going to look at the reason for the legislation. The 54 Landlord and Tenant Act could easily be circumvented if options to renew didn't come, well, the subsequent grant at least didn't come within the 54 Act, and it's against the principles of the Act. And it's not the same as an agreement to lease in the future, a contract to lease. I can understand the arguments, actually. It's quite a sort of significant argument, but it's again a bit of a policy decision, but options to grant leases, the leases can come within the 54 Act if that case is correct. I haven't seen if it's going to appeal. I'm sure Colin the Caterpillar cakes raise enough money to go to appeal. But yeah, quite a significant case.
Why is this one so significant?
One of the arguments that Landlord and Council put forward was you don't need the benefit of the 54 Act if you've got an option to renew. And that's not necessarily the case, because it's a well-known little trick. Landlords give you a sort of shortish lease and then use a non-fault ground against you, especially where you've got a lot of goodwill to build up and fitting out costs, like restaurants and the likes. Landlords can use ground F or ground G against you. They can tend to demolish, reconstruct, or ground G, occupy for their own purposes, and usurp your business for you. Do you remember we did a case last year, the lead mill, MVL Properties and the lead mill?
Yeah.
In Sheffield, where they refused leave to appeal. Well, that basically happened. So I think, to protect against landlords using non-fault grounds, most notably F and G, an option is a good idea, or a longer lease with a break. An option's a better bet for tenants than a longer lease with a break, because depending on the duration of the lease, you pay more or less stamp duty land tax or land transaction tax if you're in Wales, which depends on the duration of the lease. A 5-year lease with an option to renew for 5 years is a 5-year lease. A 10-year lease with a break is a 10-year lease. One pays less tax, which can't be a bad idea. So I'd be a bit concerned about an appeal, but we'll have to see on that. And that's why it's important.
Thank you very much, Richard.
There you go.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.